In a claim for libel, the publication, the subject of the claim must be identified in the claim form. In a claim for slander, so there is a distinction, I took it out of the scope, there is a distinction between libel and slander.
Yes, although not the way he thinks.
That's what I thought, that's why I left it alone. It's I always understood it that libel was in writing and slander was all.
No, that's what it don't. So this is the same thing.
Not
If I
necessarily
tell a
the
journalist, I mean, the basic point is, if I tell a journalist something, I am, not unreasonably, the court says, if you tell a journalist something, you've got to expect that they'll do something with it. So if I tell someone from the Sun that I have an affair with a posh bison, then I shouldn't be surprised if the Sun proves it. When Posh Spice sues the Sun and me for libeling her, then I can't say, oh, it's slander and rely on any technical differences that survive.
Right.
I will be, you told
yes.
the gossip columnist at the Sun that you had an affair with Posh Spice. Of course you did, but we're going to print it. By the way, everyone knows Posh Spice is married to David Beckham, therefore there's an innuendo of
No. In a claim for slander, the precise words used depend on the names of the persons to whom they were spoken and when must, so far as possible, be set out.
because it's,
Otherwise, how can you answer?
yes.
All rise.
Because it's a lot of May it please Your Honour, can I, before resuming the pleadings, Your Honour asked for assistance with law related to defamation and what must be pleaded.
Yes.
There isn't a defamation section in the rules of the IFC court,
No.
but there is in the civil procedure rules, which is
Yeah,
part
sure.
53.
Sure.
And I think what Your Honour had in mind was the practice direction to part 53. And that Your Honour finds in volume 1 of the White Book at page 1906.
Yeah.
I should say I'm grateful to Mr. Duties who pulled this out very quickly. I'm not an expert in libel law anymore. But 1906, practice direction PD 53, 2.1. Statements of case should be confined to the information necessary to inform the other party of the nature of the case he has to meet. Such information should be set out concisely in the manner proportionate to the subject matter of the claim. 2.2. 1. In a claim for libel, the publication of the subject of the claim must be identified in a claim form. In a claim for slander, the claim form must, so far as possible, contain the words complained of and identify the persons to whom they were spoken and when. And then the notes that explain. Publication is used in the technical sense of the term, of the instance of libel. For example, a particular document or broadcast program, which is complained of. So in the claim form, the pleader should claim, e.g., damages for libel published by the defendant on page blank of the issue of the Daily Beast dated January 1, 2017. And the paragraph 2.4 of the practice direction. In a claim for slander, the precise words used and the names of the persons to whom they were spoken and when must, so far as possible, be set out in the particulars of the claim, if not already contained in the claim form. So, it's a simple matter of practice in English defamation law. Who, what, when, where. One may say that's actually reflective of what one needs to plead across the board. It's simply the nature, the particular elements of the tort alleged.
Yeah.
Yes. I hope that decides
Thank you.
And as I said, one doesn't need to be an expert in libel law to know those basics. Mr. Haigh cannot properly simply reserve to himself the right to provide particulars in some unspecified date in the future. Your Honour, then returning to where we were before the short adjournment, we had dealt with the allegation of deceit.
Yeah.
And that then leaves the allegation of conspiracy, which paragraphs 136B and C. Subparagraph B alleges unlawful means conspiracy, which is the torts pleaded previously constituting a conspiracy.
Yeah.
And C, lawful means conspiracy, which is that if the torts aren't made out, there's still a conspiracy to injure.
Yeah.
Now, the elements of the tort of conspiracy were considered in Revenue and Customs Commission as a total network. Your Honour has that in the authorities bundle, and Your Honour finds it, yes, divided 8. It's a very long decision, very complicated decision of the House of Lords. The reason it's so long is because it's one of those reports where the Court of Appeals decisions are provided to. If I say to you, Your Honour, it's a carousel fraud,
Yeah.
Your Honour will know exactly what I mean. And it's a civil claim for carousel fraud.
Yeah.
And the issue was, leaving aside there were various complex issues about whether the revenue could claim by way of tort rather than under statute, because there was a revenue issue of was the Crown claiming tax by the back door, etc., and issues of European Union law because that is an EU tax. But the Supreme Court had occasion to consider in detail the law of conspiracy, or to consider some detail. And once again, it's Lord Neuberger who assists. And paragraph 213 is the succinct summary of the elements of the tort of conspiracy. Page 1283.
Yes.
Letters just above letter C, under the heading, if a claim in tort is permissible, is it made out on the pleadings? And Lord Neuberger said this, the Commissioner's case is advanced both in writing and orally against Total, relies on the tort of unlawful means conspiracy. It is common ground that the tort involves an arrangement between two or more parties, whereby they effectively agree that at least one of them will use unlawful means, quotation marks, against the claimant. And although damage to the claimant need not be the predominant intention of any of the parties, the claimant must have suffered loss or damage as a result. It is also common ground that all those agreements are present in the pleaded case against Total. The distinction between lawful and unlawful means is considered a couple of paragraphs later.
Yeah.
Paragraph 221. It's over the page, just about letter F.
Yes.
On the other hand, it appears that the law of tort takes a particularly censorious view where conspiracy is involved. Thus, a claim based on conspiracy to injure can be established even when no unlawful means, let alone any other action in the tort, is involved. That tort is therefore frequently described as anomalous, yet its existence is very well established. Its centrally important feature is that the conspiracy must have as its primary purpose injury to the claimant. In my judgment, given the existence of that tort, it would be anomalous if an unlawful means conspiracy could not found a cause of action, whereas here the means merely, quotes, involve a crime where the loss of the claimant is the obvious and therefore indeed in many ways the intended result of the sole purpose of the conspiracy. So the distinction between unlawful means and lawful means...
That adds nothing to the Lonwo decision of years ago, does it?
Quite so. And really, I bring this to your Lordship's attention because it's a House of Lords authority from 2008. It's current, it's the state of the art. So I'm conscious that I'm up against a little bit in person. But Your Honour is quite right, that's been the law for decades.
Long time. Yeah.
So, what Mr. Haigh must establish is an agreement. We've discussed that before the short adjournment, and there is a question over it, but I don't invite Your Honour to decide that against Mr. Haigh summarily today. But the unlawful means are the torts
Yes.
that are alleged.
Well, the point goes if you're right in relation to those elements.
I'm sorry?
The point goes, therefore, if you're right on
Indeed,
what
so-
you've submitted so
Yes,
far. But what
exactly
about the
right.
lawful means conspiracy?
So lawful means conspiracy would appear to be on the premise that it was neither unlawful for Mr. Haigh to be imprisoned, nor was his prosecution malicious. But nevertheless, it was a conspiracy to injure to report him to the Dubai authorities. Now, on one view, any report to the authorities has the intention of injuring the intended defendant. Because if the claim is that if he's prosecuted, he's going to suffer injury. The problem is it's justified injury. Now, one may approach this, like, I haven't found any authority in which a bona fide report of misconduct to the authorities has been held to be a conspiracy to injure. And nor might one expect there to be such a report. It would be an outlandish proposition. Not only that, it would be a pretty clear abuse of process, calculated, because such a claim could only ever be issued, calculated to put pressure on a complainant, either to not make the complaint or to withdraw it. And Mr. Haigh, so even if the tort could be made out on the basis that there is an agreement to report a person to the authorities which will inevitably lead to injury, it would be a gross abuse of process to bring it. So in my submission, that if there was nothing improper in our report of Mr. Haigh to the Dubai authorities, or nothing unlawful, then Mr. Haigh's real complaint is that we reported him to the police at all. That's not a conspiracy to injure. So in my submission, that is an end of the conspiracy, but there is one final point, and it would relate to quantum and or abuse. Mr. Haigh's case is that GFH Capital was, to his knowledge, a criminal organisation, effectively, engaged in international misconduct.
Yeah.
And he is seeking damages because he claims he was falsely promised and then actively pursued employment with what he believed to be a criminal organisation. Now, you're going to be aware that the Supreme Court recently refined the doctrine of illegality, but wherever the line is to be drawn, claiming damages for being deceived into believing that you were about to join a criminal conspiracy has to be the wrong side of it.
Does he claim damages for that, for future loss of earnings? On the
Well,
basis
the
of job
articulation.
opportunity? I thought it was all in relation to past loss in terms of job, salary, referral fees, commission, etc.
Well, paragraph 159,
Yeah.
139, I'm sorry,
Yes.
page 38. The defendant has suffered significant loss and damage by reason of the above, including but not limited to loss of earnings, loss of opportunity, loss of reputation, physical and psychological injuries resulting from the deceit and or conspiracy. The defendant seeks to recover awards in respect to special damages, aggravated damages, and exemplary damages. In other words, but the point is this: his claim would appear to be that he actively pursued what he says is a false indication that he could come and work for what he believes to be a criminal organisation. It's like saying that I claim damages from Pablo Escobar because he wrongly told me I could join the Medellin cartel. And indeed, when one looks at the allegations Mr. Haigh is making against us, it's not far short of an appropriate analogy. So it's a ridiculous. I use them as advisedly. It's actually quite a ridiculous claim, and Your Honour would be entitled to simply strike it out on that basis. But that then deals with conspiracy, and one then turns to the earlier parts of Mr. Haigh's pleading, where the issues are rather more subtle. And they relate to Commission's alleged breach of employment contract and the like, and the amendments to the defence. Now, if I could take them in turn, beginning with the employment contract. What I've said in the skeleton argument is paragraph 79 to 86.
So where are you going in your skeleton? Paragraph?
This is paragraph 52 of my skeleton.
Okay. Yeah.
And I said that paragraph 79 to 86
yeah.
do set out what might be considered to be counterclaims properly arising from the factual matrix giving rise to the claim. In that they allege entitlements to bonuses, entitlement to final salary, and so on. He has pleaded that we are liable for his salary with Leeds United.
Yes.
I mean, we take issue with that, but it's that is not the right of Your Honour's indication about getting into the merits of the case.
Not getting to the facts.
Yes, I might be in difficulty. But be that as it may, in essence, subject to the question of exercise of discretion, which I'll come to, that does constitute a counterclaim.
Yeah.
The earlier paragraphs, however, 75 to 78, that's really the allegations of conspiracy, false imprisonment and malicious prosecution dressed up as a breach of contract, breach of employment contract. Now, there is a difficulty for Mr. Haigh. In that, his three particularised breaches of the alleged duties under his employment contract three of the four seem to have postdated his resignation.
Well, it's a question of what's meant in paragraph 75, isn't it? At the time of the deceitful and dishonest actions and luring, etc.,
Yes.
the defendant was a group employee of the claimants and was working his notice period with the claimant when he was reappointed as a group employee.
Well, there's a hopelessly confused case as to whether he was in fact an employment or not.
He resigned, the same paragraph.
Yes.
It says he resigned as Deputy Chief Executive Officer
Yes.
of the claimant 10th of March,
Yes.
though he calls that constructive dismissal. He resigns as Managing Director
Yes.
of Leeds United on the 11th of April.
Yes.
And then this deceitful and dishonest actions, as pleaded, is April/May.
Yes.
And he appears to be saying that at that point he is already a group employee.
Well,
What that means and so on is somewhat unclear.
This is the problem. This is the problem. Mr. Haigh is an employee when it suits him and not when it doesn't.
Yes. I don't know what it means, and therefore I don't
Well,
quite know what
and
to
in
do.
my submission, given that this is the core of Mr. Haigh's complaint and has been for 3 years, Your Honour should not be grasping to try to find a meaning. In a pleading which has obviously taken some time to prepare. If Mr. Haig's pleading is ambiguous, that's probably deliberate, we would say. But in any event, litigant in person, assisting or otherwise, there's no excuse for pleading something so hopelessly ambiguous. If Your Honour doesn't know what he's trying to say,
well, can you help me by reference to...
We can't work out what he's trying to say. You see, if one turns to paragraph well, I'll come to it later, but there is a reference earlier on in the pleadings to Mr. Haigh being immediately rehired.
I remember.
And I'll come back to that if I may. But so exactly what he means by this is wholly unclear.
But it's paragraph 17E, isn't it?
Yes. It is 17E. Well, but 17, but there's two 17Es, so it's the second 17E. Yes.
Yeah. And I rather thought that might have been suggested to him by something in the WhatsApp conversations.
Well,
where it talks about if he's going to be taken on as an employee, then they don't have to talk about final service benefits and because it'll be a continuation of a salary. So I rather thought that that's what he was referring to.
No, that can't be right.
Because?
Firstly, because the defendant's final, if we go to that second paragraph 17,
yeah.
The defendant's final working day at the claimant was to be 10th of March of 2014.
Yes. Right.
The claimant, through Mr. Arrayas, however, informed the defendant after this date that he was still employed by the claimant group and would be paid in the normal course and remained an employee. Now, what Your Honour has in mind is WhatsApp conversations quite late on in the sequence.
Yeah.
So by May, I think it was early May, where Mr. Haigh is complaining that his final salary payment hasn't been calculated. As a result, he can't close out his visa,
yes.
and so on and so forth.
Yes.
And Mr. Arrayas indicates to him that if he is to be taken back on, then the salary would resume and there would be no need for a final salary payment.
Yes.
Now, whether that's right or not as a matter of the IFC employment law and Emirati employment law, I am not in a position to comment. But the point is, nowhere in March and April does Your Honour get from the WhatsApp conversations an indication from Mr. Arrayas that he is still employed in Dubai. In fact, and I took Your Honour earlier, that one of the first things in the conversations is Mr. Haigh bemoaning, I have no job in Dubai.
Yeah.
And soon no job in Leeds. So the WhatsApp conversation suggests that Mr. Haigh believed he was not employed. And there's just a very curious averment in the second paragraph 17e. That notwithstanding that he resigned, that his last working day was the 10th of March, he was informed that he was nevertheless still employed and would still be paid.
Well, what are you inviting me to do?
Well, we say paragraphs 75 to 78 can be struck out as merely a different version of the same allegations of conspiracy and deceit and the like, dressed up as a breach of employment contract rather than as torts. Paragraph 79 and following are more difficult. And I can't say to Your Honour that Your Honour can simply dismiss them summary is having no reasonable prospect of success, not disclosing any cause, no fact, or not being a proper counterclaim.
No.
So that's really a question, subject only to the question of discretion. I have to accept that those can be brought subject to Rule 18.9 and the fact that they have to be brought hitherto. But I'll come to discretion in a moment, if I may. Commissions. Now, it is unclear whether Mr. Haigh is asserting that his commission should be additional employment income, whether they are a commercial deal made with a company of which he happens to be the owner and controller and beneficiary, so that on its face it's a deal between a commercial arrangement between his employer and a third-party company for commissions, when in fact it's paying him commissions. Or what? I mean, whatever arrangement he's alleging, as a matter of UK employment law, is a very unusual arrangement if an employee is to be paid outside their employment contract by reference to a separate commercial agreement, commissions for essentially doing their job.
I thought he did say that arose on the basis of an assignment here.
Well, that comes second.
Right. Sorry, paragraph is 68, is it? Of the reading.
The commissions. Yes,
Yeah.
that's where it begins.
Yeah. So it's an agreement with 7 Dash Limited.
That's the point. So his case would appear to be, first, that the claimant entered into an agreement with 7 Dash
Yeah.
for commissions to be paid for his work.
Yes. Well,
It's a curious arrangement for anybody.
I'm not sure how curious it is.
Well,
If it's a creature of the it may not be
the reason I
which
say
tax should be dealt with and so on and so forth. But the idea of people having their own creature special vehicle companies.
it is certainly the case that one has there are many people who are employed using a service company as a vehicle for that employment.
Right.
But Mr. Haigh doesn't claim to be employed using a service
No,
company.
no, but he does. He say that the
It's,
commission is payable to
Well,
this.
that's the point. So what is curious about this is that Mr. Haigh had an employment contract, but it appears that there was then a totally separate commercial transaction with his company 7 Dash
Yes.
to pay commissions for him doing the job that he was paid to do as a salary.
Understood.
Now, be that as it may, the second stage of his claim would appear to be that the benefit of that agreement was assigned to him fairly soon after it was entered into by 7 Dash, thereby, of course, obviating any tax or other benefits that there might have been by using a service company. So, in other words, his case would appear to be that there was a referral agreement, undated, according to the pleadings. Under that referral agreement, a number of commissions became due. The total value of those commissions is some £4.8 million sterling. Although that is said to be subject to forensic accountants conducting an analysis of something. Then it appears that by a letter in or around November, so 2013, from 7 Dash to himself, 7 Dash assigned the right to the referral fee, the commissions that were now payable, following the relocation of Mr. Haigh from Dubai back to the UK. So it would appear, I believe 7 Dash is incorporated in the British Virgin Islands, but it would appear that Mr. Haigh, when living in a tax-free jurisdiction, set up a BVI vehicle to receive commissions. And as soon as he moved to a taxable jurisdiction, he unwound that so that it could become he could incur the tax liability. So there is no clear reason for that. That appears to be his case. We say it's simply not good enough for him to be pleading in this way at this stage. Once again, this is the core of his case. This is one thing that has featured throughout. It even features in the original defence.
Yeah.
Although Mr. Haigh claims that he was unable to file a counterclaim because he didn't have the money. Now, 3 years down the line, there is a referral agreement, which is recorded in paragraph 68A. An unsigned version of the contract was appended to the defence. The signed version of the contract will be disclosed in the revised amended defence when the defendant has sufficient time.
Yes.
Now, I mean, with the best will in the world, this is either treating the court with cavalier disregard and contempt. Say, I'll give you the central document when I get around to it, but take my word for it, it exists. Or this is a wholly lacking, an agreement wholly lacking in particulars. And is it an agreement wholly lacking in particulars? Well, yes, it is, because there's no date of the agreement, there's no counterparties alleged, there's no terms.
Well, I understand all of that, but the position is that the general allegation was made in the original defence.
Oh, yes.
And you haven't applied to strike that out. What you've got here is simply an objection to the permission being sought to amend.
Yes.
So what am I expected to do with that? Because that doesn't get rid of the plea in any event. It's not going to do any good, is it?
Well, the question is whether the court needs to decide the counterclaim. I'm not going to take a lot of your honour's time on this. The point is, we say this is a woefully inadequate pleading.
Well, I understand that. It's plainly
That
unparticularised, and you either apply to strike it out because it's embarrassing for want of particularisation,
yes,
or you apply for further best particulars. But I can't see how the addition of what's put in, albeit, as you said, expressed in terms, I'll do this when I can find the time,
yes,
is not a very attractive position to adopt for this court. But I can't really see how I could strike out the whole plea, and striking out the amendment doesn't really do much good.
No, well, it's purely as an exercise of discretion. I simply say to you that the existence of the Commission agreement is in the original defence.
Yes.
Whether he should be given permission to expand on that, still with no particulars, is the point. And with that, of course, if Your Honour is against me on that as a matter of discretion, it's no more appropriate for me to apply to advise Your Honour to give summary judgment in respect to the commissions than it would be on the original plea.
Right.
And it's a matter that's dealt with in any event in Mr. Patel's evidence.
Okay.
As I say, the balance of the counterclaim, it is a counterclaim, so paragraphs 79 to 86 is what one would recognise as a counterclaim.
Yeah.
Again, it's a question of discretion. Rule 18.9, which I referred you on to, says where the facts have already been pleaded and relief sought, none of this, by way of employment, outstanding employment liabilities, is in the defence, even factually. And so, indeed, Mr. Haigh appears to be suggesting that he had very much larger entitlements than his contract would suggest, and that's why he's receiving so much money to his bank account. So again, it's simply a question of discretion as to whether Mr. Haigh should be permitted to introduce this at this stage.
Yeah.
I make the point, Your Honour has it won't benefit by the
Yeah. Thank you.
And then, so far as the proposed amendments to the defence are concerned, Mr. Haigh is seeking to withdraw admissions. Now, once again, it's an exercise of discretion point, because what he seems to be saying is that because I didn't have time to prepare a properly particularised defence 3 years ago, I should now be permitted to withdraw the admissions, such admissions as I did make 3 years ago. And his assertion appears to be that he can't possibly be expected to identify, to agree how much money went into his own bank accounts without the services of a forensic accountant.
Yes, well, what are the relevant principles? My recollection is there used to be at least a series of authorities on withdrawal of admissions and the
Yes.
discretion of the court, which is not simply
Yes.
completely unfettered.
No, it's not. But we say that there is simply no foundation at all for this. He is, and to some extent it's an academic argument because it's the work of moments to prove that the money was received, because we've got his bank statements. And it's not something I propose to take up a lot of time with. It's once again it's an exercise of discretion.
All right.
The real point is that were this a significant point that he would need to press, given that he was represented when his defence was filed, the first thing one would expect is a waiver of privilege and evidence from his solicitors and or counsel at the time as to how they came to file a defence which contained admissions apparently contrary to their client's instructions. So, as a matter of discretion, we would say that Your Honour should be cautious in permitting this. And the only matter in which there is a material difference is paragraph 40 of this document.
Yes.
Which relates to Milnet. These are the payments into the bank account of Mr. Uchiyama. And he now seems to be saying not that money was paid by mistake, but that it was sent to Mr. Uchiyama's account because he was travelling and a London flat needed to be let. Then he says the subsequent payments were transferred in error, and then makes an allegation that we reused the same document to make payments but did not amend the payee details. Mr. Bijou Matthew would often make mistakes. Now, once again, these are quite specific matters, and there is an additional issue with this, in that Mr. Uchiyama was not in prison when this defence was filed. And this defence his original defence was filed 22nd of December, or 21st of December 2014, as against service of particulars of claim on 26th of May of 2014.
Mm-hmm.
So somebody had more than adequate time to phone Mr. Uchiyama to say, what's all this about? There needs to be, again, clear explanation. Again, it's not something I propose to detain you on at length. It's a matter of evidence. It can be dealt with. It's really a matter for your honest exercise of discretion. The final point is final issue is paragraph 17 to 17G, 17C. Now, Mr. Haigh says we've fabricated the claim against him in order to shut down his ability to report us to the DFSA and law enforcement agencies. So paragraph 17C, in or around this time, that must be December 2014,
Yeah.
The defendant expressed his concerns as to the conduct of Mr. Alvarez and his various breaches of DFSA rules and regulations and law. The defendant had compiled a file of his various advices to Mr. Alvarez in an attempt to prevent breaches of laws, including in relation to money laundering, bribes, insider trading, theft, false invoicing, fraud, and misuse of client money, false accounting. In particular, the defendant raised his concerns over his discovery of the use of unauthorised client funds subject to US and UN sanctions to purchase Leeds United. The defendant informed Mr. Salim Nuruddin, the group chairman and owner of the main broker of the GFH BSC shares, and Mr. Salim Patel, the director of the bank, that he intended to whistleblow in bold and to report Mr. Alvarez to the DFSA and law enforcement agencies. The defendant discussed his discovery of the actions of Mr. Alvarez with his superior face-to-face and via WhatsApp messaging. The defendant expressed his intention to resign from the claim several times, given his full discovery of Mr. Alvarez's illegal actions. And then over the page he sets out a WhatsApp extract. And then the allegations in 17E, some strange allegation related to sexuality. March 27, the second 17E, March 2014, Mr. Haigh resigned from the claimant. Defendant's final working days has been 10th of March, and we've looked at that paragraph. 17F, it was not only false invoicing and false accounting that were used by the claimant. Fake investors who did not exist were created by a member of the board of the claimant in order to receive commissions. It is not known if Mr. Alvarez was aware that such party was fake. Mr. Salim Patel fabricated an investor investing in person. Now, I mean, this whole paragraph, it's not clear what is possible relevance that all paragraphs 7 to 17C have to Mr. Haigh's case. Paragraph 17F is a purely gratuitous allegation against Salim Patel, which may or may not also be an allegation against the claimant, but which doesn't even appear to be alleged to be any part of Mr. Haigh's reasons for resignation or what he was intending to blow the whistle on. And as for the balance of the allegation in the earlier paragraphs, the gravamen of Mr. Haigh's case is the threat to whistleblow, regardless of the truth or otherwise. Now, the previous paragraphs, Mr. Haigh will make the allegations. We're resigned to that now. As soon as he's given any platform to do it, he will make the allegations. The question that I pose to Your Honour is it really necessary for us to plead to them as averments on which the court must decide, qua pleadings, as opposed to being matters of evidence, by which Mr. Haigh may or may not wish to introduce by way of background, and which we may or may not choose to rebut. We say
that you must take your own course about that. I mean, it's either the background to whistleblowing as alleged by him, or it isn't.
yes.
And I appreciate there's difficulty because of the way in which the paragraphs appear as to whether he is saying that or not. But your case, as I understand it, is that it's an immaterial averment
Yes.
for the purpose of you pursuing your claim, and in which case you can do whatever you want about it. Plead to it or not plead to it, as the case may be.
Yeah, the question is whether it's properly the subject of a defence, given that these are all additions to the defence. Whether it's properly the subject of a pleading as opposed to being matters of evidence. Because if we're not put to the expense of considering that is you doing it, such pleading as we wish, then so much the better. And indeed it's a question of focusing the pleading.
Well, I can't decide on looking at it whether it is in fact relevant to his whistleblowing allegation or not. So I'm afraid I'm trying to leave it in.
I've made one. Then I think those are the points that we wish to address. I've taken them almost, if you want to see, I've somewhat taken them in descending order of what we say.
Yeah.
Clarity can clearly be rejected. Do you want to excuse me for 1 moment?
Yes, of course.
Unless I can assist Your Honour further, there is an item.
I don't think so. Thank you very much. Right, I'll give judgment now. Having dealt with proposed claims against two non-parties arising out of the draft defence and counterclaim and application for joinder, I now turn to the rest of the proposed counterclaim and the proposed joinder of Mr. Alrays and Mr. Pater. It is worth, for the purposes of considering these aspects, drawing attention to the matters which are raised in the skeleton argument of the claimants from paragraph 2 onwards. There it is submitted that the claimant's claim is straightforward, inasmuch as Mr. Haigh is said to have breached fiduciary duties to the claimant as its Deputy Chief Executive by misappropriating substantial sums and securing payment of those sums into bank accounts held by him in Dubai and the United Kingdom, or in 2 instances to the bank account of a friend, Rafael Utiyama. Payment instructions are alleged to have been given to the claimant's bank by means of instructions which bore Mr. Haigh's signature or a facsimile of it, and payment instructions were also given to the claimant's solicitors to pay sums out of its client account for the claimant's purported benefit by emails sent from Mr. Haigh's email account. Fraudulent invoices were introduced into the claimant's records to justify the payments to Mr. Haigh, in the overwhelming majority of cases bearing some mark indicating that they had been approved for payment by Mr. Haigh. The identities of legitimate suppliers of suppliers of services were hijacked in order to create a fraudulent audit trail. In that context, the claimants recognised the possibility that Mr. Haigh may have been assisted in his scheme by employees internal to the claimant itself. Mr. Haigh's case, as it appears to be, is that the claimant and its Bahraini parent are and have throughout been effectively a criminal organisation engaged in wide-ranging and serious impropriety. The office of the claimants in Dubai employed no more than 6 people at the relevant time, including Mr. Haigh, who was Deputy Chief Executive Officer. He says he was wholly ignorant of the wrongdoing that was going on until sometime in early 2014, at which point he was spending much of his time as Managing Director of Leeds United Football Club, which was at that point owned by the claimants, but was potentially the subject of sale. For reasons which have not been explained, Mr. Haigh says he chose to create a file recording alleged improprieties and threatened to expose the claimant to the Dubai Financial Services Authority. Following the making of that threat, the draft pleading appears to say that the claimant simultaneously decided to retain Mr. Haigh as an employee, despite the fact that he had resigned, and then to lure him to Dubai, where he was to be subjected to a fabricated allegation that he had stolen funds from the claimant, and to be subjected to cruel and inhuman treatment at the hands of the authorities in Dubai, who were, it is said, ready to do the claimant's bidding. the alleged method by which Mr. Haigh is said to have been lured to Dubai was to offer him a new job. Although there is some inconsistency in the way that is put, since it is alleged that he was continuously employed by the group in any event. Nonetheless, it is said that he was to be required to fly to Dubai to agree terms of new employment and to receive salary and bonus entitlements from the expiring employment. It appears to be Mr. Haigh's case that, having formed the view that the claimant was little short of a criminal organisation in early 2014, he resigned from Leeds United Football Club, where he had continued to be employed following the sale of the club itself, and flew to Dubai hoping to secure re-employment by the very organisation of which he complains that criminal conduct was endemic. So far as the money received into his bank accounts, Mr. Haigh now claims to be unable to plead to the quantum of money received into those accounts, having previously admitted effectively or virtually all of the claim made against him in his original defence. He asserts that such sums as he may have received were properly due to him as either salary, repayment of expenses, or alleged commissions. It is noteworthy that there is no reason ever put forward for the concealment of such payments by a trail of false invoices and payments to accounts of one kind or another alleged to belong, said to belong to other entities. Mr. Haigh is a qualified solicitor. He is not the ordinary litigant in person. It is clear, as I have already said earlier in the course of rulings made at this hearing, that he has had considerable assistance from lawyers in the past, both in relation to the original defence put forward in these proceedings and in the context of other proceedings in England and Wales, and indeed in onshore Dubai. There came a point at which, however, he started to represent himself in these proceedings in August of this year. Having examined the 69-page draft amended defence and counterclaim in some detail, there is a plain inference to be drawn from its terms that Mr. Haigh has had specialist legal assistance in formulating the draft. Furthermore, Mr. Haigh has had, at least since March 2016, when he was released from prison in Dubai, to research, investigate and formulate his case for the purpose of putting it forward in these proceedings. In those circumstances, the court can see no reason to extend any latitude to Mr. Haigh of the kind that might sometimes be given to a litigant in person who is struggling to put forward, in technical legal terms, arguments which are complex in their nature. Here, in a draft pleading, Mr. Haigh has chosen to plead particular matters and has omitted to plead others, and has from time to time asserted that he has either lacked the time or resources to present a properly particularised defence or counterclaim, the court is unable to accept that this is the position, and therefore looks at the draft pleading with a view to discerning whether or not the claims put forward have realistic prospects of success, and whether the facts as pleaded are capable of amounting to the causes of action which are being put forward. It is worth noting, as I think I already have in earlier rulings, that Mr. Haigh has been involved in proceedings elsewhere, and in particular sought to bring private prosecutions of Mr. Al-Rayes and Mr. Patel to individuals who he wishes to join to his proposed counterclaim here, but abandoned those private prosecutions, having spent a great deal of money on them and having incurred liability in respect of costs in respect of them. Paragraph 9 of the claimant's skeleton argument details the giving of various other elements of litigation in which Mr. Haigh has been or is currently in one way or another involved. Before turning to the details of the draft pleading, it is worth again referring to the general approach which this court takes towards counterclaims. Where there are claims which cannot be said to give rise to either legal set-off or equitable set-off, it is usually a matter of convenience, in the sense of the court wishing to bring about the most expeditious, efficient and economic resolution of disputes between the parties. That forms the basis for the court determining whether or not matters can be heard together in the shape of claims and cross-claims. Where there is some common basis of fact or some common witnesses or overlapping elements in the claim and cross-claims, the court will ordinarily allow those matters to be heard together, because that is the most efficient way of doing so, both from the point of view of the resources of the parties and the resources of the court. I turn then to the first head of claim that Mr. Haigh wishes to bring against the claimant, against Mr. Al-Rayes and Mr. Patel, namely the claim for false imprisonment, which is to be found in paragraphs 152 to 154 of the draft pleading. There it is alleged that the matters pleaded in paragraphs 131 to 138, but with the reference, quote, check, unquote, alongside the reference to paragraph 131, constitute the facts and matters which give rise to the false imprisonment claim. In broad terms, the essence of what is being said in fact appears from paragraphs 129 to 130. Of the draft pleading, but the essence appears in paragraph 138. There appears the following wording, quote, "The claimant had within their control to ensure the release of the defendant on bail. They declined to do so. Instead, the claimant sought to use the defendant's freedom as a bargaining chip in settlement discussions. The claimant had it within their control to have Mr. Haigh released and the accusation against him dropped." Unquote. What does that plea amount to? I had thought initially that it was related to the freezing injunctions which have been granted by this court and the court in England, which tied up the assets of Mr. Haigh, so that I thought his complaint was that he was not able then to provide bail because of the inaccessibility of those funds to him. In fact, however, the freezing orders granted specifically make an exception in relation to the provision of bail. It's also apparently the case, so I was told on instructions today, that Mr. Haigh was in a position to obtain bail had he accepted the terms and complied with them, which involved the putting up as security of the sums which he was alleged to have stolen, namely some 24 million dirhams. Furthermore, his passport would have been confiscated. He doubtless says that he was not able to do that. The reality, however, appears to be this. The complaint is in truth a complaint that the claimant could have secured the release of Mr. Haigh from prison either by telling the authorities that no security needed to be provided by way of bail, or by dropping the accusations altogether. The assertion of false imprisonment, therefore, essentially brings into play the decision of the court in onshore Dubai, which was prepared to grant bail, but only on particular terms. Such a complaint falls foul of the principle set out in the decision in Hunter against the Chief Constable, because it amounts to a collateral attack on the decision-making processes of a competent court. In that context, the complainant in a criminal case can have no duty to bring about the release of a defendant on bail, even if it is in a position to suggest that to the court or to influence the court's decision to take that course. I was referred specifically to the decision in Hunter, 1981 Appeal Cases 529, at 539E and 540E to 542H. I was referred furthermore in that context to the decision of the Court of Appeal in Iqbal against the Prison Officers Association at 2010 Queen's Bench, Division 732, and in particular paragraphs 15 to 22. Paragraph 21, the Master of the Rolls, as he then was, stated that, as a general principle, defendants are not to be held liable in tort for the results of their inaction in the absence of specific duty to act, a duty which would normally arise out of the particular relationship between the claimant and the defendant. The difference, the distinction which is drawn, is between positive acts and pure omissions. Such a hard and fast distinction between action and inaction might, it was said, appear to be arbitrary to some people, but it is not unprincipled, and it is necessary to ensure a degree of clarity and certainty in the law. The nature, therefore, of the allegations made amounts to a failure on the part of the claimant to take steps which could conceivably bring about the release of Mr. Haigh on bail without the provision of security, or his complete release on the basis of dropping the accusations against him altogether. This plea is unsustainable. It is unsustainable because there can be no positive duty on the part of a claimant who has a good arguable case of embezzlement against a previous employee to drop the charges or to or to seek to persuade the court that bail should be allowed without payment of sufficient security, that security being such that the court considers appropriate in any given case. The subsequent conviction of Mr. Haigh shows that the prosecution was well founded and the complaint was well founded, and the need for security is only too evident in the context of the proceedings that have been brought since. In consequence, there can be no basis for the allegation of false imprisonment being made against the claimant, or indeed Mr. Alvarez and Mr. Patel. Turning then to the next head of claim put forward by Mr. Haigh, which is that of malicious prosecution, which appears at paragraphs 140 to 151 of the draft pleading. At paragraph 140, it is boldly alleged that the breach of trust allegations, pursuant to which the defendant was detained and prosecuted, were brought falsely by the claimant. Since the defendant was convicted of embezzlement in breach of trust, this is once again a direct challenge to the decision taken by the criminal court in onshore Dubai, and as impermissible as an abuse of process on the authority of the decision in Hunter, to which I have already referred. That is the beginning and end of the point so far as concerns the prosecution of the embezzlement in breach of trust matters. There is, however, a second area of which complaint is made, which is entitled, quote, "the Twitter charges," unquote. The details of this allegation appear at paragraphs 141 to 148. The claimant had filed a criminal complaint that Mr. Haigh was guilty of criminal libel, which is part of the law in onshore Dubai. It is perhaps worth bearing in mind that the origins of defamation as a tort in England were indeed the original offences of blasphemous or criminal libel. So it is no surprise to find that a crime of this kind exists elsewhere in the world. And there is no basis upon which this court would be considering the validity or invalidity of any such offence for all the reasons I gave yesterday about the jurisdiction of the court. Here, the key decision to which I was referred is that of the Supreme Court in Willers against Joyce, number 1, 2016 UKSC 43, (2017) 2 All England Reports 3 to 7. There, a 9-justice court considered the application of the tort of malicious prosecution as extending to civil proceedings, and by a small majority of 5 to 4, the decision was reached that the tort should so extend. In that context, Lord Toulson, at paragraph 42 and 52 to 56, set out the relevant ingredients of the tort of malicious prosecution. At paragraph 54, he set them out in a passage which, although necessarily obiter for the reasons he gave, is nonetheless of high authority. Quote, "It is well established that the requirements of absence of reasonable and probable cause and malice are separate requirements," unquote, of the tort of malicious prosecution. Those two elements may be entwined, but it is necessary for the claimant to prove both that the defendant was actuated by malice and that he had no reasonable and probable cause for prosecuting. In order to have reasonable and probable cause, the defendant does not have to believe that the proceedings will succeed. It's enough that on the material on which he acted, there was a proper case to lay before the court. Malice, however, as an additional requirement, means, quote, a wrongful act done intentionally without just cause or excuse, unquote. As applied to malicious prosecution, it requires a claimant to prove that the defendant deliberately misused the process of the court. The most obvious case, as set out, is where a claimant can prove that the defendant brought the proceedings in the knowledge that they were without foundation. There could be other instances of abuse, for example, where an individual was indifferent whether the allegation was supportable, and where the proceedings were brought not for the bona fide purpose of trying the issue, but to secure some extraneous benefit to which there was no colour of right. The critical feature which is required is to show that the proceedings instituted were not a bona fide use of the court process, and that the defendant did not have a bona fide reason to bring the proceedings. It is, I think, reasonably clear from paragraph 149 of the draft pleading that the drafter had in mind the necessity for these two elements, because there is an express plea that there was no reasonable and probable cause for the prosecution, and that the claimants and Mr. Alrayes acted maliciously. If Mr. Haigh was to make this point good, he would have to satisfy the requirements set out in Willard and Joyce and show that what was being done by the claimants was not a bona fide use of the court process, that there was no bona fide reason to bring the proceedings, and that there was not a proper case to lay before the court. The claimants would have to be shown, the claimants would have to be shown, if Mr. Haigh was to succeed, to have clear knowledge that its allegations were unfounded. It is in that context that one then turns to what is pleaded in relation to those elements. The basis of the defence which is put forward appears in paragraph 144 of the draft pleading. It is not suggested that the material of which complaint was made was not defamatory. What is said, however, is that the claimant and Mr. Alrayes must have known, and did in fact know, that Mr. Haigh, who was incarcerated in prison in Dubai, had no access to the internet whatsoever, and therefore could not have been managing his own Twitter account upon which these various defamatory remarks were to be found. What is clear on the material that has been put before the court is that Mr. Haigh was well able to communicate from prison. He was not incommunicado, as is apparently suggested in the pleading. Above all, in addition to various press releases which specifically referred to interviews from him whilst he was in prison, and the use of a device borrowed from a guard to make a call on Skype, that he also was able to ensure that Twitter feeds came from him and were published by his sister. A note has been produced to this court from Mr. Haigh to his sister, which lists a series of tweets to be put out on his behalf. Instructions are given that tweets are only to be made on his instructions. The very foundation of the defence, which is said to be matters of which the claimant and Mr. Always was aware, therefore falls to the ground. Not only did he have actual access to the internet in this way, but it is clear that there is no reason for the claimant and Mr. Always to have thought otherwise. How can it possibly be said that the test set out in Willis and Joyce is satisfied in those circumstances? The claimant and Mr. Always had reasonable and probable cause to believe that he did and could operate his Twitter account, and that material which appeared to emanate from him truly did emanate from him. Once again, that course of action is on its face unsustainable, and there is no realistic prospect of success in relation to it. There is then a further allegation of conspiracy to injure in respect of the Twitter charges. That is said to be a conspiracy to injure the defendant, to which the claimant and Mr. Always were party, and the conspiracy is said to be one to injure the defendant by unlawful means. The unlawful means pleaded in paragraph 155 of the draft pleading are the malicious prosecution and or the false imprisonment, to which I have already referred. As those elements of unlawfulness fall to the ground, so too does the conspiracy to injure in respect of the Twitter charges. Again, there is no realistic prospect of success in relation to them. There is then a further claim against the claimant and Mr. Patel, in this case for libel and slander. That appears at paragraphs 158 to 162 of the draft pleading, and it is worth referring to that in a little detail because of the absence of detail and particularity in what is set out. It reads as follows, quote, 158, the defendant is collating all the evidence of libel and slander and was unable to provide the full details at the time available, such has been the volume of the libel and slander of the defendant by the claimant, who appointed no less than 3 PR advisers to damage the reputation of the defendant. 159, on X 2015, dates, the following statements were made regarding the defendant by the claimant and specifically by Mr. Patel. A, the defendant was peddling lies and they were just lies. B, the defendant was spreading lies. C, the defendant was derailing Leeds United. D, the defendant had committed fraud, quote, the fraud committed by David, unquote. E, the defendant had stolen fans' money. 160. Numerous other defamatory statements were made regarding the defendant by the claimant and specifically by Mr. Patel and the company Woodstock Lisa, acting as agent for the claimant to a wide range of media. These will be more fully particularised in the revised amended defence and counterclaim and cannot be particularised here due to illness and insufficiency of time. 161. The statements were false and defamatory in that the statement stated that the defendant was dishonest, had committed fraud, had stolen fans' money. 162, the statements were sent to Leeds United Football Club fans and published to the BBC in the United Kingdom and distributed to a wide media audience by the then PR advisor of the claimant, retained solely to damage the defendant's reputation, unquote. What is odd, to say the least, about this plea is that although at paragraph 159 there are references to what was supposedly said by the claimant and specifically by Mr. Patel, no details are given as to when those matters were said, what exactly was said, and to whom those matters were said. The date 2015 appears without any further amplification. Because the various matters appear in quotes, it is to be assumed that at the time that the drafter put together this pleading, there was material in front of him or her showing that such matters were said. The details, therefore, should have been apparent and capable of being pleaded. To suggest that there was inability on the part of Mr. Haigh to provide full details, quote, in the time available, unquote, and by reason of, quote, illness and insufficiency of time, unquote, and that there would be more full particularisation in a revised amended defence and counterclaim, is playing fast and loose with the court. As I have already indicated, Mr. Haigh has had plenty of time to put his case together over the years, and if this was a matter to be pursued, he should be putting forward his case with due particularity. It is well known that in the context of defamation there is a need for matters to be spelt out so that the individual or company against whom the complaint is made is able to plead to it, knowing exactly what it is that is being said against him and the circumstances in which it is said that the defamation arose. It is worth pointing out that this element of the draft counterclaim is somewhat discrete from the other elements of it. The publication, as alleged, was in the United Kingdom and appears to be related in some way to a PR advisor of the claimant who is not specified specifically unless one is to read paragraph 160 and 162 and 159 together as referring to one and the same organisation, which is not a natural reading of the words used. I raise this point at this stage for one reason only. That is that the Court of Appeal, as I indicated yesterday, was prepared to give Mr. Haigh one final opportunity to support the defence already made by oral evidence and to amend his pleading by way of defence. In that context, I am clear that they would not have foreseen the likelihood of a claim for defamation of this kind being tacked on as a counterclaim to the matters with which the court was expected to deal. In these circumstances, particularly as issues appear to be raised regarding Leeds United, which otherwise essentially fall outside the ambit of these proceedings, I would think it not particularly convenient for matters to be dealt with at the same time. There is a further point which arises here in the context of damage to Mr. Haigue's reputation. For a defamation claim to succeed, it would in the ordinary way be necessary to show that damage to his reputation would result from the publication. The reputation in question is the way in which an individual is seen in the eyes of ordinary right-thinking people. Given that Mr. Haigh has been convicted of embezzlement and breach of trust, it is hard to see that referring to him as a liar or as having committed fraud could in any way have such an impact. Whilst the references to Leeds United might be particularly exciting to a given group of people, it is hard to see how the general reputation of an individual who has been convicted of the matters of which Mr. Haigh has been convicted could be lowered by the references in question. In those circumstances, it appears to me that the absence of particularisation means that the pleading is in itself an embarrassment and ought not be permitted by way of amendment. Moreover, it seems that there cannot be realistic prospects of success given the reputation of Mr. Haigh as it currently stands. If these are matters that he wishes to pursue, they are in any event matters better pursued in litigation in the United Kingdom rather than being tacked on to the matters in issue in this court. That then takes me to the claim made for deceit and conspiracy against the claimants Mr. Always and Mr. Patel, which involves the, quote, luring, quote, of Mr. Haigh to Dubai. The pleas of malicious prosecution and false imprisonment overlap with this element of claim. Because it is said that the luring of Mr. Haigh to Dubai is what gave rise to the possibility of the prosecution and the imprisonment in question. The core of the complaint in relation to deceit is that it is said that Mr. Haigh was lured to travel to Dubai under false pretenses. I have spent some time with the assistance of counsel in examining the manner in which this allegation is pleaded at paragraphs 87 through to 136 of the draft pleading. It is fair to say that none of this creates any coherent defence to the claims which are made against Mr. Haigh. And it is also fair to say that on an examination of the WhatsApp exchanges in March and April, the factual basis upon which it is put forward does not appear to be well founded. Contrary to the allegations made, what one finds on examination of the WhatsApp messages is not the slightest hint of any suggestion that Mr. Haigh is about to blow the whistle on the claimant in respect of the nefarious dealings to which he refers in his draft pleading. There is also not the slightest indication that the claimant was pressing for Mr. Haigh to go to Dubai in order to provide him with a job which had already been assured to him. To the contrary, he is found complaining that he has no job and is pursuing the claimants with a view to them providing him with a job of one kind or another, whether as general counsel, whether as an employee to work in India, whether as someone to work in London for commission, or someone with contacts in Africa which would redound to the advantage of the claimants. There is no complaint about misdoings on the part of the claimant and Mr. Always or Mr. Patel. Once again, to the contrary, it is Mr. Haigh who appears anxious to secure employment with the very organisation whose activities, he says, are so heinous. It is not for this court to decide factual issues at this stage, and indeed it cannot do so on the basis of the limited material before it, although it is fair to point out that Mr. Haigh has been given the opportunity to produce factual material to the court for the purpose of the hearing and has not taken up that opportunity. The key here, however, once again, is whether or not the pleas in question are capable of supporting the allegations made. The elements of the tort of deceit are well known, as set out in most recently in Hayward and Zurich, 2016, for All England Report 628, and conveniently by Lord Toulson at paragraph 58. There is a need for the dishonest making of false representations, for inducement and for loss. More recently, in the decision of the Supreme Court in Ivy against Genting Casinos UK Limited, 2017, UKSC 67, 2017 3 WLR 1212. The court had cause to consider the elements of dishonesty as historically enunciated in the well-known decision of the Crown against Gosh. Quote, when dishonesty is in question, the fact-finding tribunal must first ascertain subjectively the actual state of the individual's knowledge or belief as to the facts, the reasonableness or otherwise of his belief as a matter of evidence, often in practice determinative, going to whether or not the belief was held, but it is not an additional requirement that the belief must be reasonable. The question is whether it is genuinely held. When once the actual state of mind as to knowledge or belief as to facts is established, the question whether the conduct was honest or dishonest is to be determined by the fact finder by applying the objective standards of ordinary, decent people. There is no requirement that the defendant must appreciate from what he has done is by those standards dishonest. Unquote. Per Lord Hughes at paragraph 74. So the question arises then as to where is the dishonest false representation alleged in the draft pleading. In paragraph 136, it is said that, quote, the foregoing events amount to, little a, quote, deceit, fraudulent misrepresentations by the claimant Mr. Always and Mr. Patel in respect of statements made to the defendant in the knowledge that they were untrue, that, little one, he was being offered a new position and would be paid all monies owing to him, and little two, it was necessary to travel to Dubai for sign-off of the appointment and to receive monies due when they knew this to be untrue. The deceit induced the defendant to resign his employment with Leeds United Football Club and to travel to Dubai under false pretences. If one then examines the preceding paragraphs to ascertain what the foregoing events are that are referred to, one looks in vain to find material to support what is there being alleged. I have looked particularly closely at those paragraphs, and in particular paragraphs 103, 104, 108, 109, 111, 115 and 119, which are said to set out the discussions and statements of the claimant, Mr. Patel and Mr. Always, in relation to the prospect of a job and a meeting with a Dr. Khalid, who would decide whether or not such a job would be offered to Mr. Haigh. The bottom line is that paragraph 136 is not supported by the previous paragraphs. At no point before the 18th of May does Dr. Khalid, on the pleading, I'm sorry, let me say that again, at no point before the 18th of May is it said in the pleading that Dr. Khalid signs off on the appointment of Mr. Haigh as an employee. The material has been put before the court in the pleading and indeed in the WhatsApp exchanges shows that Mr. Haigh was constantly asking how he was to impress Dr. Khalid in the meeting in order to secure Dr. Khalid's approval for his employment. It is plain from the material that Dr. Khalid's sign-off was necessary before any offer was to be made. And no one was saying that there was a done deal, whether or not there was statements that suggested that Dr. Khalid could readily be satisfied as to the appropriateness of an appointment of Mr. Haigh. In the context, in the circumstances, neither paragraph 136a little 1 nor 136a little 2 are in any way supported by the prior allegations made in the pleading. There is, in truth, no plea of any false intention on the part of the claimants or the individuals concerned, no representation that a job had been offered, and no representation that money would be paid, and indeed such representations as might be inferred from the pleading appear to be representations of future conduct and not representations of fact of any kind. What is significant in this context is that the very case which is now being proposed as a case to be put here is the same case that was put before the magistrates' courts in London by way of private prosecution and was subsequently abandoned by Mr. Haigh. In this context, therefore, the claim of deceit cannot run because the necessary ingredients of such a course of action have not been pleaded. Since this is the very essence of the case which Mr. Haigh has constantly sought to put, there is no difficulty in my examining these matters with care in order to determine that no proper course of action has been pleaded. There is no need for any latitude to be given to Mr. Haigh in circumstances where he has had plenty of time and received assistance over the years in framing the claim that he wishes to put. If one then goes to paragraph 136b, one finds that the allegation of conspiracy to injure the defendant by unlawful means, which is made against the claimant Mr. Alrays and Mr. Patel, relies on the three elements to which I have already referred as the unlawful means in question. First, the deceit. Second, the unlawful arrest of imprisonment. On the basis of the breach of trust allegations or embezzlement allegations of which he was convicted. And thirdly, the unlawful arrest and imprisonment of the defendant on false Twitter abuse charges. As I have already decided that the deceit and the unlawful arrest and imprisonment allegations cannot succeed, there is no basis then for a conspiracy to injure the defendant by unlawful means. That has no realistic prospects of success either. What is left then in paragraph 136, subparagraph little c, is an allegation of a conspiracy between the claimant, Mr. Alrays and Mr. Patel, to injure the defendant by lawful means, namely facilitating or procuring an arrest and imprisonment with intent to injure. That too cannot stand. The predominant purpose of any conspiracy to injure by lawful means must be the injury of the party in question, as is established by more than one authority at the highest level in England. Here, however, there is no possible basis upon which such an allegation of conspiracy could succeed. For a report to be made to the criminal justice authorities of unlawful action or allegedly unlawful action cannot in itself constitute the basis for an allegation of conspiracy. As a matter of public policy, individuals are expected to report crimes or potential crimes to criminal justice authorities, even if they have no legal duty to do so. The idea that in doing so, with the criminal justice authorities taking such steps as they may be advised, as they did in the present case, cannot be seen as giving rise to a tort against the individual who is then subjected to arrest and trial and imprisonment at the hands of those authorities. Once again, there is no realistic prospect of success on a claim of this kind. The effect of my decisions of yesterday and today is that none of the draft counterclaim is to be permitted, save insofar as it echoes the pleas made in the defence in relation to what is alleged by the defendant to be entitlement to salary, to expenses, to commission and referral fees. At paragraphs 79 to 86, as part of the counterclaim, there is a reference to liability as alleged of the claimant for the defendant's salary, expenses, bonus and bonus shares, and various other elements which are said to represent entitlement in respect of employment. There are two additional elements, however, which fall outside that. The first is that which appears in paragraphs 75 to 78. Paragraph 75 is a most odd-looking plea. It can be cross-referenced to paragraph 17E of the amended defence, that latter paragraph coming in by way of amendment. What is said is that the defendant resigned from his position as Deputy Chief Executive Officer of the claimant on 10th March 2014 as a result of constructive dismissal, and resigned from his position as Managing Director of Leeds United Football Club on the 11th of April 2014. Quote, at the time of the deceitful and dishonest actions in luring the defendant to the UAE and fabricating false claims against him pleaded below, comma, the defendant was a group employee of the claimant and was working his notice period with the claimant when he was reappointed as a group employee, unquote. The only basis for that plea appears to be the last sentence of paragraph 17E, that is the second paragraph 17E in the draft, where it is said that the claimant, through Mr. Al-Reis, informed the defendant, that is Mr. Haigh, after the 10th of March, that he was still employed by the claimant stroke GFH BSC group and would be paid in the normal course and remained an employee, unquote. Whilst I do not find any of this very intelligible, it is put forward as the basis of express or implied duties owed to the defendant under paragraph 76. In truth, it adds little or nothing to the conspiracy allegations, and since the whole basis upon which this matter is put forward is unclear, I once again consider that the formulation of the pleading is embarrassing and makes it difficult, if not impossible, to plead to. I therefore will not be prepared to give permission to amend in relation to paragraphs 75 through to 78 as matters stand. There is additionally the amendment of the defence in paragraphs 68 through to 70. The amendment there is very limited and refers to a signed version of a contract being disclosed, quote, in the revised amended defence when the defendant has sufficient time, unquote. That is a wholly inadequate way in which to put forward a draft pleading for permission by the court. In those circumstances, those particular words should not be permitted by way of amendment. The whole plea, which was in the original defence, is again an odd one in referring to a referral agreement which has not yet been disclosed, to an assignment which again is to be disclosed in the revised amended defence when the defendant has sufficient time. Once again, that element of the amendment should not be allowed. This court is simply not going to give Mr. Haigh any form of carte blanche to produce further revised pleadings as and when he thinks he has sufficient time to do so. Otherwise, it appears to me that the pleas remain in being in the defence in essentially the form that they were originally made, since no application has been made to strike them out on any basis. There is also in the defence in paragraph 17, by way of amendment, a whole series of allegations which appear difficult to understand in the context and hard to discern their relevance. I'm not inclined to strike them out or refuse permission for them because I am unable to see whether or not they are related to the whistleblowing allegations that have been made. And in reality, you can see little difficulty in those matters being dealt with. Should they form part of any relevant issue for a trial in this matter? Finally, there is the question of withdrawal of admissions. as I have already indicated, Mr. Haigh has sought to withdraw admissions about the receipt into his account of monies in circumstances where virtually all the missing monies were found or were alleged to have been received by him or by Mr. Raphael Umitano. It is hard to understand how, in circumstances where, at the time of the defence, Mr. Haigh was represented, such admissions could be made, and now it is said that they were not properly made, and an attempt is made to withdraw them. No explanation has been given for such an approach. In the ordinary way, I would be disinclined to allow any such amendment, but here I am told that the matters are clearly established on the face of bank statements, so that the reality is no difficulty to present to the time of the court will not be extended by allowing these amendments to be made. It should not be thought that the court is amenable to amendments being made of this kind, but in the circumstances I see no prejudice resulting, and therefore I'm prepared to allow amendment to the defence in that respect. I think I have then dealt with all the elements in the draft amendments, both to the defence and to the counterclaim, about which I have been asked to make a determination, and the joinder of the various parties. For the reasons that I have given, there remains nothing to be pursued against the individual defendants, Mr. Always and Mr. Patel. There remains no counterclaim to be pursued, save that which arises out of the defence, should any such sums that are alleged to be owing by way of salary and the like overtop any claim that is made in the other direction. If I have omitted anything, perhaps Mr. Waldner would now draw that to my attention.
Your Honour, the only matter, paragraph 71 and 72, page 55, they actually flow from Your Honour's rulings yesterday.
71 and 72?
71 and 72.
Oh, yes, indeed. Well, I have already made an order in that respect, have I not? But,
yes, so
but you're quite right.
It must follow, as that follows, permission to amend in respect to paragraph 71 is refused. And paragraph 72, in light of Your Honour's comments a moment ago, that
yes.
Mr. Haigh is not free to submit any further documents as and when he feels.
Absolutely not. As with all proceedings, any further amendments which are sought must be sought with the permission of the court.
Yes. Now, there are two final matters. The first is costs. The costs of this hearing, we say Mr. Haigh should be liable for, although he's been given some limited permission to amend. That's not been what's led to the costs of a two-day hearing. It may be academic, but we ask for an order that he pay the costs of today. The costs of the 20th of November were also reserved to today. Now, the 20th of November was a case management hearing, and ordinarily the costs of the case. Now, it may be that it's a somewhat academic distinction in the long run. And I'm not going to detain you on any length of time over the issue. And given the way that Mr. Haigh has behaved with respect to bringing this order into the case, and indeed enabling him to present the evidence which the Court of Appeal gave him a final opportunity to present, and the time that the Court has been put to, the costs that we've been put to, in bringing some order to this case. My submission, this would be an exceptional case, but Mr. Haigh should be made to pay the costs of, frankly, bringing that order to the case. And so Your Honour may feel it appropriate to make an order for costs against Mr. Haigh, both for today and yesterday, and for the hearing of the 20th of November.
I think the costs of the CMC should be costs of the case.
Yes.
I think you're entitled to your costs of today and yesterday on the basis that just about everything that matters
Yes.
has been refused by me in relation to the amendments to this order.
And I should say I also appear for Mr. Arez and Mr. Patel today.
Right, but have they been put to any separate...
Well, that's what I was about to say. I don't think that they've been... Well, I certainly haven't received separate instructions to put things forward on their behalf which add to the costs. And I'm looking to my left and see him shaking his head. And so it's purely in the form of the order that the then shall move to the claimants and Mr. Arez.
The way I had anticipated this hearing proceeding was on the basis that the existing parties would present their arguments to the court, and should the court decide that other parties should be joined, then at least as a matter of theory,
Yes.
there would be room for those parties to come before the court and say why they shouldn't be joined, which would be the
Yes.
ordinary way in which these matters would happen. But I had anticipated that there were obvious difficulties with the IFC and UAE,
Yes.
and therefore the right course was for you to address the court in relation to those matters and assist the court as to its jurisdiction.
Yes.
So far as Mr. Always and Mr. Patel are concerned, they're so closely related to the claimant in this case that it really doesn't make any sense to make any separate orders.
No, I'm grateful. Then finally, it is the formal order with regard to the amendment.
Yes.
I fear that the simplest course is possibly that I recite the paragraphs which Mr. Haigh has permission to amend and say, same as aforesaid, permission to amend the defence and counterclaim is refused.
Yes, that may be the easiest way of doing it.
And what I propose to do is, rather than list paragraph by paragraph,
Yes.
as I understand it, essentially Your Honour has permitted...
Is this a document that has been supplied in a format that can be...
No.
No. Redacted, I was about to say. The answer is no. It's a PDF or something, is it?
It is. And ordinarily, Your Honour would direct the amending party to serve...
Indeed,
the
sir. I'm
final
just looking for cut through if it's possible.
Yes, a defective version. I fear that's not going to be possible. It will simply be a matter for us to plead to the document as it is. I have been diligently putting lines through paragraphs and pages as Your Honour has been giving the ruling. Just to be clear, so as I draw...
Well, I tell you what would help me.
Yes.
If you're going to draw an order,
Yes.
I obviously will have my notes. The transcript will come through, but probably not until next week, I'm told.
Yes.
And my rulings will be congregated together,
Yes.
so that they form a separate transcript, which I will then have the opportunity to prove.
Yes.
And if I could look at that at the same time as I look at your draft, and perhaps if you're prepared to do it, simply a photocopy of the document that you have where you've put lines through such paragraphs as I've disallowed,
Yes.
then we can make sure that we have an order that makes sense.
Yes, I feel sure that it's the work of moments to run this document through the court photocopier.
Indeed.
And really the way in which I propose to do it is to say paragraphs 1 to 17G,
Yeah.
the defendant has permission, paragraphs 19 to 74, paragraphs 19 to 70, and 73, 74, 79 to 86, the defendant has permission. Otherwise, permission is refused.
Pretty much, except there's some odd bits of
There is
paragraphs
some,
that
I will
refer to.
highlight that there's two parts.
It's really the
counterclaim where you're struck through the reservation of the right to pass or
indeed.
versions of the claim in due course. Yes, I will prepare that and I will forward it to the court. And then I suppose we await in due course. Your Honour's already set the timetable for an amended defence and reply to counterclaim. So we will have to get on with that. I should say,
there's an area that occurs to me might not have dealt with,
Yes.
and that's paragraph 18A, which is the abuse of process
Yes.
point. I've dealt with the case on the basis that there's nothing to be struck out on the footing of abuse of process.
Yes.
So the question is that then what remains of paragraph 18A?
Well, it would be a curious thing if if the proceedings aren't to be struck out as an abusive process, but the court should consider as part of the pleading whether the case should be struck out as
What
an
did I
abusive
order
process.
on that yesterday?
Your Honour,
Nothing.
there was no foundation for the allegation of claim to be
But
struck
made
out.
no order in relation to this part of the pleading as such.
Your Honour made no order in relation to this part of the pleading as such, but although it's called, the sequence goes paragraph 18A, paragraph 15B. The remedy which Mr. Haigh seeks, the claimant by its course of conduct as set out above and as further set out in the counterclaim below and the witness statements of Haigh, has
So it all goes.
yes, has abused the process and thus forfeited its right to take part in the trial,
Yes,
which is a strikeout by another name, really.
yes.
Uh,
And the jurisdiction, paragraph 18 as
well,
well.
that goes with
Same
Your Honour's
voice.
ruling, yes.
Yeah. Indeed. All right. Well, I think that's tolerably clear then.
Yes. I'm grateful.
Are you happy that you have my rulings sufficiently?
It remains to thank Your Honour for time.
Well, it was better to, I think,
Long last,
deal with that on an extemporary basis.
oh, absolutely. At long last, there is order out of the chaos and stuff.
Well, maybe. So the next stages in the programme are for you to plead
Yes.
to the amendments, and then I forget what the next stages
I
are, but the
believe it's,
timetable simply runs, doesn't
Yes,
it?
it does. There's a timetable to trial. I think the next stage is disclosure.
Yes.
And on the subject of disclosure, whilst I'm on my feet and very briefly, Your Honour raised at the CFC the question of the scope of disclosure and whether the IBA rules apply. The answer actually is in Part 28 of the RDC.
Yes.
The reason I say that is because if one considers Part 28 and juxtaposes Part 31 of the CPR, see, it's the IBA rules. They've been amended to reflect the fact that this is a court and not an arbitration.
Yes.
But it is the IBA rules and therefore the IBA scope of disclosure. Right. That, I fear, is a point that we will be addressing Your Honour on in due course, because Mr. Haigh has already made his application for disclosure of essentially the whole of GFH's business records from 2008 onwards. But be that as it may, we'll wait until he makes such applications as he makes. Yes. One final matter at the risk of volunteering work to my instructing solicitors. We do have largely, prepared for other purposes, a volume which contains all of the judgments that various courts and tribunals have given in this case. Would it be of assistance to Your Honour if we update that so that it's available as a single volume in the way that medical evidence is, just in case of future reference?
Yes. Well, I'm sort of cobbled together a
Yeah.
slight version of my own, but it would be best if there was
Yes.
one which was uniform, so we can all refer to it should we need to at any point. That
Yes.
would be helpful.
I don't ask not to give a direction as to when that will happen.
No,
Let's do it.
no, well, if it could be done before we have a further hearing, that would be undoubtedly beneficial. Thank you very much, Mr. Doover. Good. I think that's it. Thank you very much.
All rise.